Thank you for joining us. Landiger, Verano & Davis is an employment law firm exclusively representing employers and business owners. We're going to talk today about most expensive mistakes to avoid as a California employer. Next slide. The first single most expensive thing for an employer to face is a wage and hour class action lawsuit. Now, what is that, you might ask? A class action is a type of representative suit that involves claims that are made by one individual on behalf of a large group that are similarly situated. There is an authority to bring that type of lawsuit. It comes from the California Code of Civil Procedure, Section 382. Now, in order to be able to bring that type of lawsuit, the type of issues that the employees face must have some commonality. In other words, they must have all been wronged by the employer in the same type of way. There's also what's called numerosity requirement. In other words, there have to be a certain number of employees in order for an employee to bring a class action. Now, it is a myth, though, that it takes thousands of employees to be able to make up a class action. In fact, under California Supreme Court case, the court upheld a class that was as small as 10 to 15 individuals. So even if you are a smaller employer, you can still face this type of lawsuit. Now, in order for an employee to be able to get this type of lawsuit approved, they have to go through what's called the certification process. And a judge in a court has full discretion to be able to look at the arguments that the employee makes and to find for or against this type of matter. Next slide. There are different types of class actions. Now, since we are in the employment law arena, there are various, any or all of the following may be issues in a class action. For example, an employer may fail to pay minimum wage to an hourly non-exempt employee. They may be failing to pay them for overtime that they're working past 8 hours in a day or past 40 hours in a work week. They may be failing to permit and authorize meal and rest breaks to employees. They may be failing to reimburse employees for necessary business expenses, such as using your cell phone or using your personal vehicle to perform daily or weekly job tasks for work. And another example is failing to furnish proper itemized wage statements or pay stubs. Next slide. Without a single plaintiff, there can be no class action. So in order for this type of mechanism to work, a single employee must exist to be able to bring the class. And in order to induce a plaintiff into doing so, the law compensates an individual for becoming a class representative to participate in the lawsuit. So a class representative who files a class action in California is eligible for what's called an incentive payment to compensate them for bringing this class action. So therein lies the incentive for an individual to bring, for an employee to bring this type of lawsuit on behalf of all the other employees. So it's not entirely altruistic. What makes this one of the costliest lawsuits or piece of litigation for an employer is the fact that there are various categories that the would-be settlement is divided into. For example, it's divided among the class representative, as I just mentioned, the employee who brings this class action, all the plaintiffs in the lawsuit. So let's say you've employed several hundreds or several thousands of employees. So the lawsuit will be distributed among those employees. The court costs, administration costs, a third-party administrator has to administer and pay out the settlement. And don't forget the lawyer's fees, which end up being pretty high. Next slide. And this next one is a very costly problem that hits a lot of our clients. And this is one of the largest and newer pitfalls of California law. And it's called the Private Attorneys General Act of 2004, for which the acronym PAGA is used. PAGA was enacted by the LWDA, the Labor and Workforce Development Agency, to enforce California labor laws. You want to be aware of what PAGA is because a lot of my clients are facing it and it's very costly. What it does is it allows employees to sue for any labor code violations that we've discussed just a minute ago. So meal break violations, rest break violations, overtime, minimum wage. And what it does is it essentially deputizes private attorneys to be able to file lawsuits on behalf of those employees. And unfortunately, because it significantly increases the price, the cost of this type of lawsuit, it has been abused, as you can imagine. So attorneys can leverage these PAGA penalties to get bigger settlements, even if the claims have no merit. And the cost of doing business has suddenly gone up significantly. So employers end up paying hefty sums with much of the money going towards attorneys' fees and relatively little going to workers in the state. Next slide. Now, as you can see, based on the statistics in this slide, since the law took effect in 2004, the lawsuits have increased exponentially by more than 1,000%. It almost sounds fictional, but it's unfortunately true. So as one of examples, next slide, please. One of the most frequent issues that our clients face in class action and PAGA lawsuits revolve around alleged meal and rest break violations. So one of these types of violations, the meal break violation, has recently undergone significant change. Types of violations, the meal break violation, has recently undergone significant change in the law that governs that type of break, a meal break. So what you want to be aware of is that in February of 2021, the California Supreme Court issued a significant decision pertaining to what's called rounding. And rounding, it has been a practice that many employers perform. And what it is it's essentially an employer can round time punches for either meal or overtime, or when an employee punches in for the day or clocks out for the day. And rounding time punches has been historically a common timekeeping practice. So an employer may, for example, round time punches to the nearest 5 minutes or to the nearest 1/10 or a quarter of an hour. And based on this new decision, Donohue versus AMN Services, the court held that rounding may no longer be applied to meal periods. So what does that mean? What that means is when an employee goes to lunch at 12 o'clock, or let's say 12:03, and returns from lunch at 12:24, you may no longer round those numbers to the nearest 10th, right? So for example, you may have been able to do something like rounded to 220, but now you have to actually, under the law, keep it at 223 in order for you to be compliant with this law, okay? So bottom line for you to be aware of is that the court held you may no longer round when it comes to meal breaks, or you will have violated the law and be subject to pretty hefty penalties, okay? And unfortunately, you cannot claim ignorance as a defense, although it's tempting. At the end of the day, you may end up having a lawsuit, and if your time cards reflect a practice of rounding when it comes to meal breaks, then unfortunately you will have the exposure under this type of law. So definitely be aware, and don't make the mistake that may end up costing you thousands of dollars. Okay, so it's very important for you to be in touch with an employment attorney who can advise you on how to structure your policies correctly, notably your meal and rest break policies, as well as your overtime policies. And don't forget that a timekeeping policy is very important for you to have that's in compliance with California law. Thank you for listening today, and stay tuned for additional topics that may be relevant to your business.